lawyer's
Sir,
reaction.
I'm asking you to move your foot out of my door. They do not have a warrant in hand. And if they did, I would comply. I want to see a warrant to enter my place. Oh, you don't have it? I have a right to see the warrant. I want to see the warrant to enter these premises.
Now in this video, it does not appear that there were any exigent circumstances, nor does it appear that these police officers were in pursuit of a suspect who immediately ran into the house and they were trying to apprehend that suspect. Instead, the police say that they were waiting for a search order to arrive and wanted to speak to her regarding some event. When she refused to do so, this officer put his foot out to prevent her from closing the door, and that is unlawful. But ladies and gentlemen, what you should absolutely not do is slam the door on the officer's foot and makes these officers' actions unjustifiable police force.
Welcome back, everybody. As many of you guys know, I'm a law enforcement trainer instructor. I train and instruct military and law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, advanced criminal investigations, etc. And in this video, the reason why we're doing this video breakdown is because I got a question, as you can see here on your screen, and this person asked me, well, tell me what to do if a cop's foot is in my door across the threshold. He's in my home without consent, a warrant, or a violent felony committed in their presence. How much trespass past the door is okay? 6 millimeters, 6 inches, or 6 feet? How do I get his trespassing foot back out of the threshold and him off the curtilage of my home? And that's a good question. And let me just start off with saying that this is not legal advice. I'm not here to give you legal advice. I would highly recommend that you contact a lawyer and talk to a lawyer about these hypothetical issues as they relate to you. With that being said, I can tell you what I would absolutely do. So again, this is just advice for myself. This is what I would do in this situation. And I also have to be honest with my biases. The reason why I would do this is because, number one, I know the case law precedents. Number two, I know how law enforcement thinks, how they operate. And number three, I don't commit crimes. So this is absolutely how I would handle this situation. But before we can really dive into what I would do, we have to know the why. And so the first thing that I think that we need to understand and talk about here is kind of curtilage and the case law about it. So there's Supreme Court case precedents, as you can see here on your screen. Florida versus Jardines, 2013. The Supreme Court had affirmed that the right of a man to retreat into his own home and there be free of unreasonable governmental intrusion is the very core of the Fourth Amendment. The area immediately surrounding the associated with the home, the curtilage is part of the home itself for Fourth Amendment purposes. The front porch is the classic exemplar of an area to which the activity of home life extends. So the Supreme Court has said emphatically, without equivocation, that the curtilage outside the front of your house is considered protected. So regardless if we're talking about putting your foot in the door or just the fact that they're on the porch, that would be considered the curtilage of a home. So just for 100% transparency purposes, that would be something that's important to note and recognize. But again, we're talking about the foot being in the door. So there's that case law precedence. The next thing that I think we have to understand is what is an arrest? And so there's two case laws that are very specific to what we're talking about here. So I'm going to go over two. One is in the First Circuit Court of Appeals. The second one is in the 10th Circuit Court of Appeals. So let's start with the First Circuit. In French versus Merrill, the court concluded that any reasonable officer would have understood that repeated forceful knocking on the front door and bedroom window frame while urging French to come out during the officer's third and fourth entries exceeded the limited scope of the customary special license to enter French's property. By doing so, the court concluded the officers engaged in the kind of warrantless and unlicensed physical intrusion on French's property that Jardines clearly establishes as a Fourth Amendment violation. As a result, the court held the officers were not entitled to qualified immunity. So that's one. The second one is at the 10th Circuit, which is where I'm from, or where I'm at, I should say. The police repeatedly knocked on the defendant's motel room door. After calling him on the phone numerous times, they pounded on the door they pounded on the door for at least 20 minutes. This amounted to a de facto arrest, and because it occurred at the defendant's motel room, was unconstitutional absence of a search warrant. The fact the officers remained outside is not critical. The defendant had been inside and was clearly under the belief that he was required to come out of the house. And that's United States versus Reeves, 2008. And so the reason why we were talking about this case law and the reason why I'm mentioning it is because, again, everybody is going to have to, you're going to have to do, again, talk to your lawyer, figure out between you and your lawyer what you would do in these hypothetical situations. But again, for me, what I would do and what I would give myself advice to, again, I'm only speaking for myself, what I would do, I would absolutely go with a template that forces law enforcement hand. So essentially what I would do is I put myself in a winning situation where I'm either going to let them know that am I being detained, and we're going to go down that route. And ultimately, we're going to force the arrest. So if they want to make the arrest, I'm going to make it as easy for them as possible to make that unwarranted, unconstitutional arrest. So this is what I would do, 1 through 7. These are my exact steps, and this is absolutely how I would do it. As you can see here on your screen, the first thing I want to know is, am I being detained? Brown v. Texas, 1979, establishes that a law enforcement needs reasonable articulable suspicion of a crime before they can detain and compel you to identify. So the first thing I want to know is, am I being detained? So if he says, yes, you're being detained, okay, cool. So I know at this point that a seizure, that seizure has been done. So this law enforcement officer has seized me. His intent is to seize me. And if his foot's in the door, that is a physical act, right? So that would totally be covered under Torres v. Madrid. So he absolutely has detained me, and he has seized me, not only based upon his words and affirmations, but based upon his behavior and conduct, 110%. Number 2, I'm going to let the police officer know I don't consent to any searches or seizures of my property, and that would be pursuant to in accordance with United States v. Jones, 2012. Now, what next thing I'm going to do, and I always do this, I want to give them a way out, right? So they're either going to take this and they're going to back off, or they're going to go forward with it, which is going to clearly establish another constitutional right violation. So I do that by stating, if you wish to violate my rights, I keep my wallet and my identification that has my identification and credentials insert here in my left back pocket, in my right back pocket, in my front pocket, right? So I'm going to let them know, if you wish to violate my rights, this is where you can get my identification and credentials. Again, they're going to take that and they're going to either, hey, I need to take a few steps back here, or they're just going to do it. Really, for me, it's of no consequence. And let me caveat this by saying the reason why I go about this in this way is because I'm trying to do 3 things, right? I'm not trying to make a cool video for YouTube. That is not what I'm trying to do. I'm trying to do 3 things. I'm trying to have my cake and eat it too. So I want to maximize survivability with this law enforcement encounter. So I want to maximize my survivability. I want to affirm my constitutionally protected rights, and I want to maximize law enforcement accountability. So this is the best way I can get all 3, because all 3 are important. I want to survive the encounter, I want to affirm my constitutional rights, and I want to maximize accountability for law enforcement. The next thing I'm going to say is for your safety, my safety, I'm going to keep my hands interlaced on top of my head. Because again, remember, if I can't shut the door because the foot's there, I'm not going to slam it on the officer's foot. I'm not going to cause a situation that can be interpreted in any way that's going to look hostile or violent or anything like that. Again, and that's not going to do me any favors. So I'm going to, in my home, put my hands on top of my head, interlace my fingers. I'm going to leave them there.